welcome to NYU Abu Dhabi. I'm going to first ask if you would consolidate yourselves. So Mr. Kadri doesn't have to go like this, and there's a sense of density in the middle. So would you mind doing that, sort of moving to the end of the row? And maybe moving forward? One side or? No, it's okay. I think we can be split. Do you mind moving over?
I just don't want to be, I'm waiting for something.
Okay. Okay, I really have, I'm repressing my desire to be even bossier and need more of you, but I'll repress that. Okay. So, NYU, this is the home of NYU Abu Dhabi in New York, which is a campus of NYU, now in its third year in Abu Dhabi, where we have a little under 500 students who are pursuing programs in 22 different majors in the liberal arts. It is a widely diverse student body with students coming from 90 different countries. We've just recruited our next class, and we will be growing to approximately 2,200 undergraduates. We've had quite extraordinary experiences with our students, about 100 of whom are actually in New York this semester, and an even larger number will be here this summer, which stands for the exchange that we have between New York and Abu Dhabi, both at the student level and the faculty level. So we'd be happy to answer any questions you may have about the project, one dimension of which is hosting programs here in 19 Washington Square North about a range of topics that connect our New York and our Abu Dhabi campuses, but also topics related to the history, society, culture of the Middle East writ large. And that is the general umbrella which frames tonight's lecture. I read the review in the New York Times of Sadakat Kadri's most recent book and thought, this book sounds absolutely fascinating. This is a must-read and someone who we needed to bring to 19 Washington Square North, so I'm delighted he could join us tonight. He was trained at Trinity College, Cambridge, and at Harvard Law School before starting his practice as a barrister in London, where he specializes in constitutional law, criminal law, and human rights. His work in international human rights has had many interesting it included many interesting activities. He has observed court proceedings on behalf of the Geneva-based organization International Parliamentary Union, and he went to Syria in March 2011 as part of a delegation of an international bar association, where he wrote a report that formed the basis of Syria's suspension from the International Bar Association last summer. There was a similar fact-finding trip that he took on behalf of the same International Bar Association in Myanmar. One wonders as you read his CV how he has had time to write the books of the depth and of the travels that are described in those books. His first book was called The Trial, A History from Socrates to O.J. Simpson, which was published in 2005. And the book, which tonight's talk will be based on, is entitled Heaven on Earth, A Journey Through Sharia Law from the Deserts of Ancient Arabia to the Modern Muslim World, published by Farrar, Straus, and Giroux. The book is downstairs, available for sale, and I hope that you wouldn't mind signing copies if any of our audience members would like that. So please join me in welcoming Sadakat Kadri.
Thank you all very much for coming along today. And thank you, Professor, for inviting me. I'm extremely grateful to you and to everyone at NYU Abu Dhabi who's helped to make this a bit possible. I'm just sorry that the person I was meant to be speaking with, Professor Shari'a, can't be here today. She apparently had a family problem, and it would have been a great privilege to be speaking with her as well, because she's written articles on several of the issues that I'm going to be touching on today. There's just one silver lining in relation to that cloud, which is that when I was told that she wasn't going to be able to attend, I was asked if I minded speaking by myself. And I kind of had visions of an empty room, and I'm very glad that you're all able to turn up today, so thank you. So, the Sharia, what does it mean? As a matter of etymology, it's simple enough. The word meant in the 7th century a direct path to water, which was obviously for a desert people like the Arabs a pretty important route. And its metaphorical meaning is probably pretty obvious. It meant the route towards salvation. It was the path you took if you wanted to be delivered from the tribulations all around you. It's got a precise Jewish equivalent, the halacha, and in my book I say that the closest English equivalent is the straight and narrow. But of course, it isn't the commonalities, the features that the Sharia has in common with other religions that people focus on these days. It's the differences. Sharia has become one of those words that people don't have opinions about so much as they have stances. And some of those stances have been adopted in the Muslim world, and that's a subject that I'm going to be coming on to, of course, in a few moments. But they do also exist closer to home. Within this country, an entire movement has grown up called the American Laws for American Courts movement, which is devoted to the idea that the Sharia is a repressive political doctrine. It scored its first victory back in late 2010 when it persuaded the voters of Oklahoma to pass an amendment to the state constitution which outlawed courts from considering or using Sharia law in any circumstances. Now, the courts of Oklahoma had never in fact considered or used Sharia law, but that was irrelevant as far as they were concerned. But that attempt was struck down as unconstitutional. So they changed tack and they began to target foreign laws in general. That wasn't entirely convincing, in that some of them quite regularly forgot that they weren't meant to be speaking just about Muslims and continued their attacks on the Sharia. But they did score another win last summer in Kansas, where the governor, Sam Brownback, enacted a piece of legislation which now instructs courts not to recognise any foreign law or legal system that would not grant the parties the same rights guaranteed by state and US constitutions. Now, one hopes that American courts are upholding constitutional rights in any event, but I'm not going to talk about that subject in any great detail today. We can get onto it during questions and answers if anyone's interested. The reason I mention it is simply because it illustrates one thing, which is that there's a lot of fear and ignorance surrounding the concept of Sharia. And when I say that, I'm not simply trying to score a cheap point against the people who are fearful and ignorant. Because it's normal not to be frightened of things that you don't understand. And I was myself. I was scared myself. And that's in fact why I wrote my book. And to explain that, I'm afraid that I will have to go back to a day that we all remember, 9/11. And the reason I say I'm afraid is because it's become something of a cliche to regard 9/11 as a moment of blinding clarity when the world changed and when everything became clear. But despite that risk, I really do think my story began there, because in July 2001, I had just been commissioned to write the book that Professor Farrar mentioned, The Trial, A History from Socrates to O.J. Simpson, and I had decided that I'd come to the country where the trial as a social political institution was biggest, the United States. So I found myself a sublet in downtown Manhattan, in Greenwich Village, in fact, just about a quarter of a mile away from here. Its big selling point was that it had a view of the World Trade Center. And so on September the 11th, I woke up to see the towers burning and see them collapse. And I spent the next 2.5 years in this country. I left in late 2003. And during that time, as those of you who were here as well will remember, Islam and ideas about Islamic law were almost never out of the news. There were claims and counterclaims about what Islam did and didn't require. But although I was interested, because I'm a Muslim myself and I'm obviously a lawyer, I stuck diligently to my subject, which was Western jurisprudence. The arguments of Muslim extremists weren't what I was writing about, and I made that very clear when the book eventually came out. This is what I said. Whether the quality of Western justice is better or worse than that of other cultures is a question that I happily duck. But though I was happy to duck the question, it just wouldn't stay ducked, because my book was published in London in April 2005, and 3 months later we had what we in England call 7/7, which was the bombing of our transit system by 4 Muslim men who claimed God as their inspiration. And over the next few weeks, exactly the same process that I'd seen in New York happened all over again. There were, on one side, many people, lots of people, who said, look, Islam itself is a word which is derived from the Arabic word for peace. And so violence is necessarily against what Islam teaches. That was fine as far as it went. I know plenty of Muslims, and of course I know that the vast majority are Pacific, peace-loving people, but it didn't seem to go very far, because it assumed what it set out to prove. But on the other hand, the counter-argument struck me as very unsatisfactory as well, because there were plenty of people who said, well look, these people say that they're killing people in the name of God, that they're fighting a jihad, a holy war, so why don't we just take them at their word? Because Islam and Islamic law is actually a violent religion. It is a religion which demands that you kill infidels. And as I say, I didn't find that at all convincing, because although I was as frightened of being blown up as the next person, I also knew that that was not the faith in which I'd been raised. It didn't represent the views of any of the Muslims that I knew myself, and plenty of the people who said that they were condemning extremism seemed to me to be contemptuous of Muslims as a group. So I started to feel a little, well, I realised my ignorance, and I actually started to feel a little bit guilty about my ignorance. And I figured that the spot of research was in order. I already knew that the Quran wasn't a legal document, except in the sense, of course, that the Old Testament could be regarded as a legal code. And I assumed, because I'm a lawyer, and because I'm a legal historian, I assumed that the way to proceed would be to go and find the core texts, and I assumed there'd be a number of core texts which would set down the rules of the Sharia, and then I could find out how those texts have been interpreted over the years. But as I began to ask around, I realised that it wouldn't be at all as straightforward as I thought. The first person I spoke to was my father, who's also a lawyer, also a Muslim, and he of course confirmed that the suicide bombing was against the rules of the Sharia. But when I asked him why, where is it laid down, he first of all pointed me to the Quran, and he mentioned hadiths, which are traditions about the Prophet, which I'll talk about in due course. But when I said, well, of course I'm sure there are statements about it, well, where does the Sharia say that these things are forbidden? And he shrugged his shoulders and he said, you have to speak to a mullah about that, an Islamic scholar. Friends of mine, Muslim friends of mine, were equally ignorant. And as I quickly began to realise, the only thing, in fact, that most Muslims knew about the Sharia was that there was someone else who knew a lot more than they did. And so that's why I decided that I would write the book that I did, Heaven on Earth. And it turned out that the Sharia, far from being a rigid code of rules, was more malleable, more flexible than any system of law that I'd ever come across. There's actually another word which is used to describe the rules of Islamic law. Sharia itself is a spiritual concept, but there's a word, fiqh, which means understanding or discernment in Arabic. And that describes the human attempt to approximate the Sharia, which is regarded as a perfect system of justice. And the do's and the don'ts that are laid down, that have been laid down by fiqh over the centuries, are virtually infinite. Most of you will know that Islamic law extends to things which in the Western context we wouldn't regard as being legal, things like diet and dress. But that, it turns out, is just the start. I'm going to read a short paragraph from the prologue of my book just to show how broad the scope of fiqh is actually regarded in Islam. The science of studying the Sharia, jurisprudence, or fiqh, came to be considered a duty akin to prayer. No aspect of creation fell outside its scope, and jurists pronounced on questions from the lawfulness of logic to the legal meaning of the moon. They hypothesized fantastically unfortunate dilemmas. What Muslims should do on a desert island, for example, if they ever found themselves pining away alongside a dead shipmate, a pig, and a flask of wine. Clue: avoid pork and alcohol until desperate. While some would always focus on big issues such as criminal justice and jihad, others explored far more specialised aspects of the cosmic order, the calculation of inheritance shares, say, or the jurisprudence of ablutions, and no problem was ever too personal to escape their collective gaze. Al-Ghazali, an 11th century scholar who's conventionally regarded as one of the greatest of all Sunni theologians, once subjected the intimacies of marriage to rigorous legal scrutiny, and attributed to the Prophet Muhammad himself a commandment on the importance of foreplay. Now, whatever else might be said about the merits of foreplay, the idea that it was a commandment under Islamic law came as a surprise to me. And it wasn't the only one, because once you start reading the Quran, looking through it for hard and fast rules, you quickly realise that it isn't typified by commands at all. It's invitations to reflect that one reads throughout the Quran. There are 5,000, there's slightly more than 5,000 verses in the Quran. But although those verses identify plenty of sins, like blasphemy, like renouncing the faith of Islam, apostasy, those are backed up by promises of heaven and warnings of hellfire. And earthly sanctions are entirely exceptional. In fact, in those 5,000 verses, one can find only 4 mandatory punishments in total. Those 4 are, first of all, remember we're talking about the 7th century here. The first offence is theft, which is made punishable by amputation of the hand. The second is adultery, which is made punishable in the Quran by 100 lashes. Not stoning, 100 lashes. Stoning was a later interpretation. That's counterbalanced by the third offence, which is false accusations of adultery, which is made punishable by 80 lashes. So there you see there's a safeguard, an evidential safeguard. And the fourth offence is it's roughly translatable as violent disorder. And that last offence carries 3 possible sentences in the discretion of the judge. And it's got to be said that one of them is the death penalty, crucifixion, no less. But of course it wasn't Muslims who invented crucifixion, it was the Romans and the Persians. And it's mandatory death sentences just don't exist in the Quran. The closest you get is an optional death sentence, which comes from a passage which explicitly cites the Torah, in which and according to the Quran, in which there is great light. And that allows individuals to retaliate. It allows them to take an eye for an eye, a tooth for a tooth, etc. But the very next verse after granting that permission urges believers to forego punishment and be merciful instead. Now, when I point that out, I'm not making apologies, and I'm not trying to argue for the imposition of such penalties today, because of course I don't believe that they should be applied today. I'm a human rights lawyer after all. And I'm certainly not justifying a system like that one sees in Saudi Arabia, where very recently one saw a court reportedly, at least, ordering a sentence of paralysis as retaliation for someone who caused the paralysis of someone else. The Saudi authorities have denied that sentence was ever passed, it's got to be said, but it's certainly the case that they have ordered blindings, court-ordered blindings and court-ordered amputations have been made in the past. I'm not justifying those things, and I never would. The reason I point that out, I point out what the Quran says and the context of the 7th century, is because it lays the ground for precisely the opposite kind of argument, which I think is the only rational argument that one could draw from the verses of the Quran. The Quran's transmission, when it was written down, which according to Muslim tradition was between the 630s and the 650s, according to in the Christian calendar, represented a moral revolution. According to Islam's own traditions, the culture that it had replaced, the culture that Islam had replaced, was one which allowed for the burial of infant girls, and one in which slavery was a hereditary stigma. Now, Islam, of course, ended infanticide, and although it allowed for slavery, it said that emancipation was one of the greatest things that one could do. Now, again, I'm not pointing those things out to say that they're necessarily true or that they were necessarily acted upon, but if one's going to look at the evidence, one has to look at how Muslims themselves perceived their history. And if one reads the earliest texts, which date from around the 9th century and the 10th century, one sees that these were the things that Muslims were themselves writing about the Quran and about the culture that they'd taken over, the culture of ignorance, or jahiliyyah, as it's known in Islam. They took immense pride in their attitude to things like female emancipation, to female women's rights and the emancipation of slaves. And the Quran itself was just the beginning of the legal story. Over the century after it was written down, between 650 and 750, the desert Arabs began to expand. And within that century, they had created an empire which stretched from Samarkand in Central Asia all the way to Seville in Andalusia, or Spain. And lawyers began to plug the gaps that they perceived in the Quran. Gaps in the sense that 4 criminal punishments weren't enough to govern an empire. And as they began to create a more rounded and fuller legal system, they drew on a huge variety of material, including a huge variety of non-Muslim material, from ideas from Zoroastrians about political theory, to Greek logic. One of the very first of Islamic jurists was a man called Abu Hanifa, who worked in the town of Kufa in Iraq, and the Persians had, of course, incorporated a lot of Greek philosophy, and it was through that conduit, through Iraq and Iran, that Islam came to know about Greek ideas about logic, and logic and reasoning became an integral part of legal jurisprudence. But the process was an incredibly lengthy one. The first textbooks weren't written down for more than a century, and a very important aspect of Islamic jurisprudence, hadiths, or stories about the Prophet's life, weren't actually collected for 250 years after the Prophet's death, the 9th century. And the process of creating a legal system didn't even begin to settle down until the 12th century, until the 1100s. And so that's half a millennium, that's 500 years after the Quran had made its appearance. By then, you had four major schools of jurisprudence that had appeared, Sunni jurisprudence. I'm not going to go into the details of the distinction between Sunni and Shia, but there was a distinction. And you had four major schools of Sunni jurisprudence, a separate, distinct body of Shia jurisprudence, and even then the legal evolution continued. There were hugely significant events like the Mongol invasions of the Muslim world, led by Genghis Khan in the early 1200s, and then the subsequent growth of tremendous empires like the Mughals, the Ottomans and the Safavids, all of which would play a part in altering people's understandings of Islamic law. The upshot of that potted history is simple. The scope for interpreting Islamic law is absolutely immense. Scholars of the Quran themselves have always recognised that the verses of the Quran have to be contextualised. They simply have to be contextualised because the Quran is said by Muslim tradition to have been revealed over a period of 20 years. So some verses simply are regarded, this is conventional Islamic thought, are regarded as having been superseded by other verses. So you can't simply just look at a verse of the Quran and say, well, this is the law, because it may well have been taken over by other verses. There are instructions in the Quran. There are 3 separate instructions in the Quran about what you do about drunkenness, for example, none of which refer to violent punishment, but all of which refer to different ways in which it should be criticised. And that's conventionally explained as being because the Prophet's revelations about what God regarded as the sin of drunkenness, those revelations changed over that 20-year period. So it's absolutely conventional to say that the Quran's verses themselves have to be contextualised. And exactly the same thing is true of the hadiths. There are literally thousands of hadiths which were written, as I say, or collected, set down in written form 250 years after the Prophet's death. And though they're collectively considered sacred, it's logically impossible to believe that they're all true. There are a handful which make claims which are absent from the Quran. There are hadiths, for example, which say that adulterers should be stoned to death, to go back to one of the crimes that I mentioned earlier on, one of the sins that I mentioned earlier on. There are hadiths which say that it's also lawful to execute homosexuals, blasphemers, apostates. But although there are hadiths which say this, there are also hadiths which say that the Prophet didn't punish such sins, or that he turned a blind eye to them. And there are plenty of them, far, far more, which stress the value of repentance and of mercy than those which stress compulsion. So it's literally impossible to treat every rule as a command, even in theory. The overwhelming majority of those rules in any event have nothing to do with compulsion or enforcement. They're moral lessons that are drawn from the Prophet's life, and many of them, the majority of them, concern things like ritual, theology, cosmology, and manners. And so that has a very important practical consequence. When people focus on rigidity and punishment, that's a choice that they're making. That isn't something that's simply a fact about the Sharia. So the crucial question isn't what the Sharia is, it's who should decide what it is. Now, there's never been a simple answer to that in Islam. Classical Sunni jurisprudence certainly claimed to offer one. It's about 1,200 years ago. It said on the basis of a hadith which attributed to the Prophet a claim that Muslims would never agree on anything in error. Jurists said that therefore that meant that anything that Muslims agreed upon by consensus was part of the Sharia. But of course that only deepened the riddle, because who makes up the consensus? Does it include all adult Muslims? Did it include just male Muslims? Did it include just clever scholarly male Muslims. Now, it's got to be said that there were plenty of scholarly male Muslims who thought that the answer was in the question there. They said that it was male lawyers who made up the consensus. But even they didn't speak with a single voice. There was a 10th century jurist by the name of Muhammad al-Tabari who argued that tradition allowed women to sit in judgment on contested questions of the Sharia. And al-Tabari was not just any scholar. He knew a thing or two about tradition because he was the greatest historian that Islam has ever produced, the Islam's equivalent of Gibbon. He produced I think 35 or 40 volume history. This is in the 10th century of everything that Islam has done until then. And even more fundamentally, it was widely assumed among the first Muslims that ascertaining the Sharia wasn't a public act at all, that it was a sacred endeavour, an endeavour known as ijtihad. Ijtihad comes from the Arabic word, the Arabic verb jahada, which means to strive or to struggle. And though it might seem natural today to assume that laws exist to be enforced, that wasn't, in fact, how the early Muslims regarded it at all. As far as they were concerned, the Sharia described secret truths of a world beyond human ken. And when the first caliphs, Abbasid caliphs in the middle of the 8th century, asked scholars, tried to co-opt scholars to decide contested questions of the Sharia for them, those scholars were hesitant, to say the least. Again, I'm going to read a very short paragraph from my book to illustrate that. Chronicles about this period are littered with tales of men who underwent floggings or feigned madness to escape the burdens of service as a judge. The prevalent attitude is illustrated vividly, but not atypically, by the story of a North African scholar who was instructed to decide a case according to the Sharia by the governor of the Maghreb. He had to be escorted under armed guard to the mosque and agreed to hear the litigants only after the governor's guards tied him up, took him to the roof, and threatened to throw him off. Even then, he cried so much that the parties decided it would be better for all concerned if they took their quarrel elsewhere. Although the temptations of judicial office would soon win over some scholars, others would continue dodging appointment for decades, and it remained a professional convention until the 10th century that anyone recruited as a judge would greet the news by weeping profusely and lamenting his lot. Now, that humility has certainly changed. Islamic judges aren't known for crying rather than reaching decisions about the Sharia these days. And that process took place as states coalesced. But in what way did that process take place? Well, some basic facts are easy enough to state, modern facts. If you look around the world today, there's some 50 Muslim majority states, and about half of them make reference in their constitutions to Islam. To Islam and as being connected somehow to the law. Around a dozen of those states specifically refer to the Sharia, stating that it's either a source of legislation or it's a body of law that can't be contradicted. Or in the case of Saudi Arabia, it's simply said that the Sharia is the law of the land. There isn't, I think, well, there is now a constitution, but it's simply left to judges to interpret the Sharia as they see fit. But where do those constitutional arrangements come from? Because they're not simply traditional. The very concept of statehood has changed so much over the years that that's not possible. And if you look at history again, you'll see that it certainly wasn't traditional. The first attempt to lay down, to set down the rules of Islamic law in a form other than in the Quran was regarded as so heretical because it wasn't man's job, it wasn't humanity's job to write down the laws of God. That was God's prerogative only. It was so heretical that the first person to suggest it in the late 8th century was executed for his pains. And though Muslims have certainly had to deal with brutal rulers just as much as any other people, Islamic states have actually enforced the specific penalties laid down in the Quran exceptionally. I'll just give one illustration of that because it's absolutely striking and it surprised me hugely when I found it out. The Ottoman Empire, the empire that ruled that's now Turkey, conquered with Constantinople in 1453. It lasted for some 500 years, and over the course of its 5-century existence, as far as we can tell from looking at recorded sources, the total number of stonings to death of adulterers during that 500-year period was precisely one. There's one recorded case of stoning to death for adultery in the Ottoman Empire during that half a millennium. And the truth is that those countries that make the loudest claims to godliness today are creatures of modernity through and through. If we went back 40 years ago, there was just one country in the whole world which claimed to enforce the Sharia in full, and that was Saudi Arabia, which itself had been formed after a bitter civil war in the 1920s. It was only in the 1970s when the nationalist pan-Arabism, for those of you who know something about the history of the region, as that was discredited by, particularly by the Yom Kippur War, by defeat, by the Arab world's defeat by Israel in 1967, things began to change. But the first person who introduced Islamic law in statutory form, again, remember this is something which, as I've said, is traditionally heretical, he was no paragon of orthodoxy. It was Colonel Muammar Gaddafi in Libya, and he did it a few years after he took power in a coup in the late 1960s to outflank his religious opponents. He wasn't he's certainly not regarded as a pillar of orthodoxy by the Muslim world now or even then. But he authorised amputations and lashings. Then in 1977, another military man took power in Pakistan, and he presided over a similar lurch to authoritarianism. It was General Zia-ul-Haq, and he started a process called Islamisation. But the very first rules, the very first floggings that he carried out were actually bequeathed by, were carried out pursuant to laws which had been bequeathed to Pakistan by the British. It was a law and order agenda that he was pursuing under the cloak of Islamisation. Then came 1979. In 1979, you had Iranian clerics seizing control of the revolution that had begun to roll through Iran, and of course we know what happened after that. The very first stoning of modern times outside Saudi Arabia took place in 1980. And at the end of 1979, the Soviets, of course, invaded Afghanistan, setting off a train of events that are still with us today in badlands between Pakistan and Afghanistan. Through the 1980s, as that process of radicalisation intensified, you saw President Julius Nyerere, again someone who'd taken, a military man who'd taken power as a result of the coup, introduced Islamic penalties in Sudan. Civil war began in Somalia, and then through the 1990s, Afghanistan, Nigeria, etc., etc. And I'll just give one example of how that had practical effects on the ground. Changes to the concept of jihad. And the word itself, as I've already mentioned, comes from, in the context of ijtihad, comes from jihada, to struggle. And it conventionally describes all sorts of battles. There's the jihad of the heart, there's jihad of the tongue, there's jihad of the hand, and there's also jihad of the sword. Now, the last one has, of course, been understood to authorise just wars in the name of God. That's been the case since the 8th century. But the arbitrary brutalities with which it's associated today are very much a product of modernity. For 12 centuries before the partition of Palestine and the creation of Israel in 1948, it was a fundamental tenet of Islamic law that a jihad of the sword could only be declared, could only be waged on the direct orders of a ruler. That changed in 1948 because the Muslim Brotherhood took it on itself when states failed to prevent the creation of Israel, took it on itself to say that it could, in certain circumstances, promote jihad. And that gradually built up until then. This process in the 1970s that I've talked about occurred, and in 1979 you got the very first justification for freelance assassinations of political leaders. That was in Egypt, and it produced the assassination of Anwar Sadat in 1981, and protests that and that was a direct response to the Camp David cause. Suicide bombing, an act which violates explicit prohibitions in the Quran and Hadiths, was absolutely unheard of until 1983, when it appeared for the very first time in the so-called martyrdom operation in Lebanon, a year after that country had been invaded. So it isn't unbroken tradition that underpins modern efforts to give effect to the Sharia. It's coups and it's revolutions and it's wars and it's occupations. And the connection between political volatility and Islamic revivalism continues to operate today. The arguments about putting Sharia into effect aren't emerging from settled interpretations of ancient texts. They're the product of war zones in places like Mali and Somalia, and of revolutionary upheavals in countries of the Maghreb and Northern Africa, where the Arab Spring began. And they're fueled by the same controversy that's been puzzling Muslims for 1400 years. Not what the Sharia is, but who should decide. I was going to end by examining how that debate has been playing out in one of the most pivotal and emblematic of states of the Arab Spring, Egypt. But I'm conscious of the time, so perhaps I'll leave that for questions and answers. But I just note that there's a very lively debate that's taking place there at the moment. I say lively, that's almost a euphemism. But about the role that scholars should play versus politicians in interpreting the Sharia, because it's been the case in the Egyptian constitution for more than 40 years. It was Anwar Sadat himself who introduced a provision in the constitution saying that the principles of the Sharia shall be a main source of legislation, which was then changed to be the main source of legislation in Egypt. And all the parties are now focusing on what that means and who should decide what the principles of the Sharia are. And those people who, I'm sure no one in this room thinks this, but those people who imagine that there's some brilliantly thought out Islamist conspiracy in Egypt where everyone is working openly or otherwise towards the same goal, should just have a look at how that debate is playing, because you've got the Salafists against the Muslim Brotherhood, against Al-Azhar, against the secularists, all of who have got different takes on how this thing should play out. And however that conflict is going to be resolved, it's a reminder of the point that I've been trying to make today, which is that the Sharia isn't a blueprint. It's regarded by Muslims as an ideal. The overwhelming majority of devout Muslims who talk about following the Sharia are simply trying to do the right thing by God in the hope of the ordered and predictable life. Some politicians are certainly conflating the ideal perfection of the Sharia with the earthbound rules of fiqh. But, of course, it's a very, very dangerous thing to exploit faith for self-serving ends. And that makes the question of legitimacy absolutely crucial. And again, in the context of Egypt, there's a real problem there, because the constitution, the new constitution that was passed in late 2012, was enacted following a referendum during which 2/3 of voters supported it, but only 1/5 of Egyptians supported the new constitution. And the Muslim Brotherhood, which has always been characterised by a gradualist approach to legal change, is in danger of forgetting the lesson that gave it such success in the past, which is that gradual growth and genuine grassroots support is absolutely essential if Islamic ideas are going to form the basis for a stable political system. Now, when I make observations like that, I don't want to give any credence at all. I just make this clear to those people who say that the Sharia represents a danger in this country. Requiring courts to ignore foreign laws is either completely superfluous, because they should be upholding constitutional rights in any case, and insofar as foreign laws contradict them, then they should be ignoring them, or it's a disguised demand that Muslims cease to express their own faith, which is obviously discriminatory, it's counterproductive, and it's fundamentally unconstitutional. But within Islamic societies, the opposite risk is growing. The Sharia is being presented as a kind of talisman, a panacea to solve all ills, while debates about the mechanics of its operation are being mystified. The eternal qualities that have always been attributed to God by devout Muslims are being invoked to obscure the fact that it's mortals, and particularly male mortals, who are advancing contested arguments to promote political agendas. And that matters to us all, wherever we live. Islamist politicians in the Muslim world aren't going to stop appealing to divine justice in the near future. And if you believe in democracy and free speech, there's no reason that they should. But those politicians, and anyone concerned with the future of those countries, should have regard, I would argue, to Islamic history. Among Muslims, that calls for a critical assessment of how Islamic law actually developed, not to contradict pious traditions, but to complement them. Religion has been the glue in the Muslim world that's held it together for more than 1400 years, almost exactly as long as Christianity dominated the West. But the Islam that took root over 3 continents over those 1400 years spread precisely because its rules were adaptable and flexible. Today, intransigent law and order agendas and sectarianism are all too often crowding out alternative values that are conventionally credited to the Prophet Muhammad. Traditions of tolerance and leniency, for example, and they're suppressing debates about why values like that matter in the first place. And there's a corresponding obligation on people in the West, whether those people are Muslim or non-Muslim. All of us and our leaders have to engage intelligently with the attempt that's currently underway in the Muslim world to reconfigure Islamic law into a 21st century doctrine. That may well call for criticisms, and I've made plenty of them today, especially when Muslim politicians exploit or pander to religious fervour for partisan ends. But it also involves restraint. There have been some terrible abuses. Just to take some recent examples, almost at random, we've seen the sentence of paralysis in Saudi Arabia that I mentioned. We've seen riots against Copts in Egypt, which violate traditions of tolerance that Muslims themselves have regarded as absolutely paramount for centuries. There are, of course, acid attacks against women in many parts of South Asia, not only among Muslims, but certainly they've been justified by faith on occasion. But anyone who's concerned with human rights knows it's not only Muslims who can act brutally, of course. And no matter how much one might support a separation between church and state, and I myself speak as a committed secularist, Islam has become a manifestation of political identity over the last few decades in the Muslim world, and more particularly over the last couple of years since the so-called Arab Spring began. To imagine reversing that process is absolutely futile, and it's essential instead, I would argue, to acknowledge that the Sharia can be seen by Muslims as an aspiration, and to support those people who are trying to repair our differences rather than to promote ways of accentuating them. And that's all that I've got to say. Thank you very much. Now, I'm quite happy to take questions if there are any people who've got any questions. I should have prepared some myself. Oh yeah, there's one over there.
I was going to say that it was mostly political volatility that leads to a call for the implementation of Sharia law, because in the UK you have a debate going, or I don't know, it's still going when I was there, about giving religious courts some more prominence, and I know
Sure.
it's just a ruling that recognizes recognized a Jewish divorce. But
Sure.
It hasn't, or someone, can you speak to that and also where you stand on it?
Sure. Yeah, the debate that's going on in England is, I don't know if it, well, I'll just repeat the question. The question is what's the situation that's going on in England regarding acknowledgement of Islamic law by official institutions, and what do I think about it? There's, first, the debate has been kind of polarised, and it's misleading, because there's this idea that Islamic, a couple of years ago, in 2008 in fact, the Archbishop of Canterbury made a speech where he said that the acknowledgement of Islamic law was inevitable, and it caused a complete furore. Everyone was up in arms and said, this is scandalous, it's eroding the rule of law, there should just be one system of justice for everyone, and ever since then there have been campaigns against the recognition of Sharia law. Now, I'm trying to work out how to, but I'll explain what the situation is. Basically, there is not a parallel system of justice in the United Kingdom. There are arbitration tribunals and there are mediation bodies. The difference between them is that a mediation body is effectively where someone is, where two parties will go to someone who will try to sort out their disagreement. It's voluntary and it doesn't have any legal effect. The marriage guidance counsellors would be one example of a mediation body. You also have arbitration, which is different in the sense that two people will go to an arbitrator who, under circumstances, well, by definition, if the arbitrator is recognised under the Arbitration Act in England, they will go voluntarily, they will sign a piece of paper which will say that, that they will accept the arbitrator's decision, and the arbitrator can then, or arbitrators, can then reach a decision which will be upheld by the courts. So it will have legal effect in that sense. It will be secondarily lawful in that sense. But there are incredibly important safeguards behind all this. First of all, it's absolutely voluntary. There's no question that someone can be subjected to these things against their will. There is a question about how that works with people who are vulnerable, like, for example, women who aren't aware of their legal rights, which I'll come on to in a moment. But in principle, it only applies to people who go into these things voluntarily. And insofar as courts have the power to uphold the arbitration awards, which is they're not relevant for mediation, but insofar as they have the power to uphold arbitration awards, there are also safeguards. It can't be contrary to the Human Rights Act, which is our equivalent of the Bill of Rights. It can't affect the rights of children, because that's contrary to the best interests of the child, is the term that's used, because that's contrary to the Convention on the Rights of the Child, which the United Kingdom acknowledges through the Children's Act. It also can't, they don't have any jurisdiction over family matters generally, like ancillary relief in the case of divorce, and they don't have any jurisdiction over criminal matters. So the idea that there's this parallel system of justice which is kind of operating in secret and is being given legal effect, it just isn't true. There is a report which was published by a group called Civitas which claims, and this is a statistic that gets bandied about, so I may as well just put it on the record here. They said there's 85 of these tribunals in England. If you read the report and then look at the footnotes, you find out that he's assessing that there probably are about 85 of them, some of which are in mosques, some of which are in private houses. He hasn't actually spoken to any of the people concerned, etc., etc. So the evidence that there are abuses taking place is very, very, very scanty. That isn't to say that abuses couldn't take place or don't take place. I suspect they probably do, because of course you could get a woman who would be told, look, just sign this piece of paper here, and everything will be fine because you're going to be judged according to the rules of Islam. Now that's a problem, but the way that one resolves that isn't to say that these things should not take place at all, because a woman who's that vulnerable is unfortunately going to be willing to sign away her rights anyway. If it doesn't take place before an arbitration tribunal, she's going to be doing that in a mosque, or she's going to be doing that in her own home. And this actually operates as a safeguard, having arbitration tribunals, because they are challengeable in the High Court. They're subject to the glare of publicity, etc., etc. And I'll just end by saying that you mentioned the Jewish tribunals. The Beit Din have been around in the UK since the early 1700s. They do exactly the same thing, so it would be discriminatory to say that Muslims shouldn't do that, for starters. In this country, you've of course got the Beit Din, but you've also had a Federal Arbitration Act since 1925, and it's been a policy of the Supreme Court since the 1980s to say that people should use arbitration. And Sharia arbitrations in this country have been upheld for years and years. And there are plenty of cases where that takes place. And most of these arbitrations, almost all of these arbitrations, are commercial arbitrations, where people just say that we want to be judged according to Islamic law. They're entirely voluntary. They're subject in this country to the Bill of Rights, and in the UK to the Human Rights Act. And unless and until someone points clear evidence of a problem and identifies a clear solution, I would say that legal reform in that field isn't necessary. Please.
As a growing number of Muslims who, Americans who are embracing Islam, and they have non-Muslim parents, and say that there's a huge community of Muslims in the New York metro area who have non-Muslim parents, and their parents are like middle class and they own property. What are the rights? You know, it's a big story in the mosque all around New York about Muslims not being able to inherit property from their parents.
You mean about Muslims not being able to inherit property from their parents?
Yeah, from their non-Muslim parents.
Unfortunately, you kind of got me there. I mean, I'm not an expert on inheritance law. I'd be very surprised if that's the case. I thought you were going to ask a question about the difference between male and female, because there is obviously there's the rule that a daughter inherits half the amount from a son, which does cause problems.
There's emails going out that it's an established thing that we're not allowed to inherit from non-Muslim relatives, like property. So I don't know if you're a practicing lawyer in America or not.
Well, I'm a qualified lawyer in America. I'm not a practicing lawyer in America, and my field isn't probate or inheritance in any event. So I'm really sorry. I'm just going to have to put my hands up and confess ignorance to that. But I'm very interested. I mean, I'm going to, now that you've mentioned it, I'm going to look it up myself. I mean, I'm startled by that because I can't. I mean, I can see that there are arguments that the parents aren't going to be bound by Islamic laws about how inheritance should take place, because the Islamic laws are going to apply to Muslims. I can't see that there are arguments for saying that the Sharia or fiqh or Islamic law is going to prohibit people from accepting that. I'd be very surprised. I mean, I think that probably unless you know any better, I think that probably what's going on is that they're saying, well, we're not going to assess this according to Islamic rules of how inheritance shares should be divided, because there are very specific rules about who gets what, and that may be what's going on, and that I can understand the rationale behind that. But that of course wouldn't stop people from inheriting. It would simply say that this isn't going to occur.
If I can exchange the email, I can send you some information.
Sure, no, very interesting. Yeah, please.
And even when we talk about inheritance as according to Sharia law, there is also in the Quran mentioned that after a will is being given and after debts are paid. So after debts are paid and a will is given, then there are certain divisions are to be made.
Sure.
And these are in the interpretation. So if the son is doing very well and the daughter is not, the parent could give twice to the daughter as to the son.
Sure. Oh yeah. No, there are very good arguments for saying that for getting around the idea that a girl, a daughter, inherits half of that of the son. No, I agree with you completely. Yeah.
And that's all in the Quran actually. It's
Sure.
just unfortunate that.
Sure, but there is that verse which is sometimes taken to say that the default position should be that a daughter inherits half of that of a son. But of course, the testator is free to make alternative provisions, because there's a third that the testator can donate in any event. Yeah, please.
Dr. Kadri, you mentioned the 4 Sunni schools of Islamic law, but I was curious, in your book, you also mentioned the Shiite schools and their evolution, particularly the Twelvers and the Seveners, and within them, as Twelverism evolved into Akhbarism, Rasulism, and its ramifications, because, in this day and age, Rasulism is the default form of Shiism, and its implications are pretty huge.
Sure. No, the implications are huge, which is one of the reasons why I didn't go into the minute detail there. But yeah, I covered the Sunni Shia split in some considerable detail. My book is, the first half of it is a history, and the second half of it involves me travelling, me talking to scholars, me talking to believers in many parts of the Muslim world. I started in my father's birthplace, but then the country, in fact, where I spent longest was Iran, where I spent a month. And I talked to plenty of people there, including Ayatollahs. Also, I was in Lebanon. But again, I had to keep the book in manageable proportions. It's a 300 odd page book, and so I don't kind of go into great details about the differences between the Ibadi school and inheritance, etc., or whatever. It's But I talk about the reasons for the split, because I think that that's fundamentally important, that people understand this thing, because normally people will just, they're just aware that to get tabloid about this, that Sunnis are blowing up Shia and Shia are being victims of Sunnis in parts of the world, but I kind of thought it was very important to set out the history there. So there's a lot of that stuff in the book, and about how the rules developed differently. But the same process that I've described basically operates for the development of Shia law. It's just that different sets of hadiths are given credence to. There's less emphasis, for example, on consensus, because as far as the Shia were concerned, the consensus was just majority rule by people who had no interest in Shiism at all. So yeah. Can I take another question after that, please?
Of those countries that either utilize Sharia law exclusively or significantly, do they interpret it according to one of those 4 Sunni schools of law? Except in the case of Iran, which would be Shia.
Which would be Shia. They tend not to. They don't. So a country like Saudi Arabia, a school known as Hanbali, the Hanbalites, they were named after a particular scholar from the 9th century, tends to be dominant, and the interpretations of the law that are given tend to come from that school.
And some are more conservative than others.
It is more conservative in certain senses. It's very difficult, because the thing is that schools have. When I started this thing, as I say, I started from a very ignorant base, and I assumed, well, there's going to be one conservative school, there's going to be one liberal school, and then the other 2 would be somewhere in between. I didn't know what. But actually, it's not like that at all. There are certainly things that one can say about the different schools. The Hanbali school will place more emphasis on hadiths, for example, and that's why I would argue that it creates a potentially very arbitrary legal system. Because in Saudi Arabia, it's sufficient to, a judge can potentially at least just pluck one of these 5,000 hadiths and say, well, this is the one that I'm going to rely on. It isn't quite as simple as that at all, because you have to, there are centuries of scholarship which have gone into which hadiths are regarded as respectable and which ones aren't. But there is, that tends to promote arbitrariness among judges who are authorized to apply Hanbali law, whereas the Hanafites, this school that I mentioned, which was the first to incorporate Greek logic into Islamic law, they tend to argue by analogy far more. But as that suggests, that can produce results which are just as repressive or just as liberal as any other. You can analogize between resisting a bully and suicide bombing an invader just as easily as you can do. You get my point. I'll come back to you in a minute. You've already had one crack over. I'll come back in a minute. Please.
My question is, does your argument apply to women's rights. You made a reference in passing to at the time the Quran was written, if I understood correctly, there being an emancipatory aspect to it, and you mentioned women as well. But then that gender theme fell out of the argument. So if you could describe whether the long story that you were telling about Shari'a is also relevant to the impact of Shari'a on women.
It's hugely relevant, because the process that took place was obviously dominated by men. You had during the Prophet's lifetime, many of his companions, a vast number of his companions, were women. You've got in the 8th century the first biographies of Muslims are written down, and 20% of the Muslims whose lives are recorded in that biography, and there are hundreds of lives that are recorded there. 20% of them are women. One of the biggest sources of hadiths in Islam is the Prophet's favourite wife, Aisha, who is said to have been who's said to have been responsible for I think it's more than 2,000 hadiths in total. But the process that took place of collecting the hadiths and of drawing up legal principles on the basis of those hadiths and on the basis of other scholarly tools was dominated by men. There's no escaping that. And so what tended to happen was that these female perspectives fell out of the picture. I can't remember now precisely how many of those 2,000 hadiths of Aisha were accepted, for example, in the most canonical work of the collection of hadiths, but it's a very small number. It's a very, very small number. And you do have, and there are plenty of scholars who are doing some important work in this field, you do have female scholars of hadiths who were regarded with great respect during the formative period of Islamic law, during the 9th and the 10th and the 11th centuries. But it's the same process that one sees in history everywhere, which is that the contributions of these women tend to get forgotten. They're not written about, they tend to be less literate. And so, that's one of the big challenges that needs to be addressed today, and that certain scholars, feminist scholars, are addressing today, which is to recover that history. But it's a huge task, because the problem is that the sources that are regarded as authoritative, that have been regarded for centuries as authoritative, are male-dominated sources. And to say, well, actually, we should look beyond these authoritative sources, you're immediately open to the challenge from conservatives, which is, well, they're not authoritative. And so, that's how the process operated in the general kind of long history that I was talking about.
If those sources were recovered, is it that there would be a tradition that could be established of equal rights for women under the rubric of Sharia?
Well, there'd have to be. The argument that would have to be used is that there's a concept of the Sharia which is the maqasid Sharia, the goal of the Sharia. And the argument would have to be that, for example, when the Quran was established, it was a progressive instrument. When the Quran was written down, it was a progressive instrument which increased the rights of women far beyond those that they previously enjoyed. That's something which is absolutely conventional in Islamic historiography, in Islamic theology, in Islamic law. And so the argument would have to be that, well, the goal of the Sharia is therefore to increase the rights of women further. That this isn't a glass ceiling, this is a glass floor, this is a floor. The right should only advance from there. A good analogy, I suppose, would be emancipation of slavery. As I mentioned, the Quran allows for slavery as an institution because it simply doesn't abolish it. It acknowledges that slavery is an institution, it regulates it, but it does also talk about the great value of emancipation and the need to end it. And nowadays, there's not an Islamic country in the world which hasn't signed up to the Anti-Slavery Convention. There's almost no scholars anywhere in the world who will proudly stand up and say Islam is a religion which supports slavery. And there's a reason for that. There is in fact one scholar who I mentioned in my book who did say that, which is, and the fact that it's so shocking that this Iranian scholar should say that is itself, I think, proof of the general point, which is that, look, things have moved on since the 7th and the 8th centuries. Slavery was once permissible among Muslims, it was once regulatable among Muslims, just as it was permissible among Christians and permissible among Jews during that period. But in the 21st century, we need to bring that to an end. And insofar as there are benighted scholars in parts of the world who do still support slavery, they're acting contrary to the ultimate goal of the Sharia. And so that kind of argument would be used to say that the rights of women weren't equal in the 7th century, but they represented a massive increase on what happened before. They were far more equal than, for example, in the West. This is the kind of argument which Muslims will use all the time. And so you can move on from that to say that equality is the goal to which one's moving. Please, Arthur, go on, your way.
I was wondering if you could speak a little bit to the way that Islam is, how technology is affecting the practice of Islam in like national political context. Like I'm thinking of those online religious leaders who consult about things, or televangelists who have an audience across the Arabic-speaking world. Like, can you talk a little bit about how that is?
Sure. I mean, it's completely unknowable, unfortunately. I mean, it is a huge development. I mean, you have these televangelists who are now addressing millions and millions of people. I mean, the development was first kind of seen in the 1980s when we had cassette tapes, where sermons were being passed around from person to person, and they kind of made it to other countries. But then, you know, since things have gone online, the process has just gone completely crazy. I mean, you've got millions of people listening regularly to sermons which are taking place thousands of miles away. You know, one hears the kind of headline issues like al-Laki in Yemen supporting ideas of jihad, which then supposedly at least inspire acts in the United States and in other countries in the West. But there are other ways in which these ideas are also having an effect. I mean, one very interesting example is the growth of online fatwa sites, where you have, I mean, for those people who don't know, a fatwa isn't, well, you may have heard of the word fatwa because it's notorious that Ayatollah Khomeini issued a fatwa in 1989 ruling that Salman Rushdie deserved death for writing his novel The Satanic Verses. But a fatwa isn't simply a sentence of death. A fatwa is any ruling issued by a mufti, and the mufti is an Islamic scholar. And so it's basically just an opinion about Islamic law. And it has more or less weight depending on the extent to which the scholar is regarded as respectable by this elusive consensus of Muslims. And in the past, fatwas have kind of operated on a very local level. You've had majasas where people have gone along and they've spoken to effectively the Muslim equivalent of the priest, and they've told him their problems, and he said to them, this is what Islamic law, the Mufti has said, this is what Islamic law requires of you, this is what you should do in the case of this dilemma. But now you've got this extraordinary explosion of online fatwa sites, which only started in the late 1970s, late 1990s. I think the first one was Fatwa Online, I can't remember, but you get people emailing in questions from all over the world, and you know they're the kind of questions that you could see in any problem page. You know, problems about boyfriends, problems about sex, drugs, rock and roll, anything. So this process, which was once a very intimate, personal process, is going completely global. Anyone can, and I did while I was researching my book. Anyone can just search these online archives of fatwas. If you've got a problem, if you've got a dilemma, maybe it's already been answered. You know, just go onto one of these online fatwa sites and find out. I mean, the recall fondly myself was one which was someone who was very troubled by the question of Facebook, and because he wrote to, I think it was Islam Q&A, saying that he didn't want to be troubled by Facebook messages all the time. But was it okay for him to not to update his status, to explain where he was all the time, or to explain what he was doing all the time? And so these muftis, I think they were based in either Qatar or in Egypt, devoted paragraphs to the question of whether or not it was permissible to not update your Facebook status, and they ended it by saying, "And God knows best." But the answer is just it's impossible to know whether these things are going to homogenise understandings of Islam, or whether they're just going to create even more.
Or like take away the power of something like a state-based authority.
They certainly are taking power away, but again, that's a double-edged sword, to use a perhaps unfortunate analogy, because one of the other things that's taken power away from states has been the growth of freelance jihadis. Al-Qaeda is a quintessential example of the kind of movement away from powers of the state, and so whether it's a good or bad thing, we just have to wait to see.
One last question?
One last question, yeah.
Following up on Hillary's question about women's rights, I'm curious, did you go to Morocco? Apologize for not reading your book. Did you?
To Morocco?
To Morocco, yeah. And there was like this, such a groundswell of hope that this Madonna would be like this great sort of renaissance of Maliki law. And I'm curious, everyone was sort of waiting to see how it would turn out. I'm curious to see if you.
No, I'm actually going there with my father in July. I'm going to be spending a week there, so I'll be curious to find out myself. But perhaps I can ask you, how has it turned out? I remember when I went to Syria. No, but when I went to Syria, one of the lawyers that I went with was a Moroccan lawyer, and he was very enthusiastic then about the king's reforms, and said that we aren't going to have the same trouble. Libya was just kicking off at that point, and well, Syria was kicking off, and Libya had already happened. But he was saying, well, it's not going to happen in Morocco because it's all been resolved. But I don't know. Sorry?
It's all been figured out.
But I'm guessing that it hasn't all been figured out. Yeah, I can't answer your question, but thank you for the question.
Can we just add one more question at Syria?
Sure.
Which is very, very powerful. What is your opinion about Syria? What is the solution to that problem?
The solution to Syria?
Really, if there's a solution at all.
Well, I mean, all that I can say is that it's my personal experience, and it's not a religious thing. I mean, I was there. We arrived 2 days after the first demonstrations in Farrar. It was I think it was the day after. It was 3 days after. I think it was the day after the first shootings had occurred. And while we were in Damascus, the first demonstration against the regime happened. And we wrote a report about it, and I gave an interview about it to coincide with the Morton report. And I've listened to it relatively recently, and it still holds up. I mean, it was a self-fulfilling prophecy, what went on. I mean, now, of course, there are some terrible abuses being committed by the anti-regime forces. That was always going to happen. I mean, there were 10 years of squandered chances by the government, and the government just failed to grasp any of those chances. And I haven't been there now since that time. One just has to hope that the forces of secularism are strong enough, because there was always one thing that we heard again and again and again from the government, particularly from the government side, when we were interviewing people. The government was, look, Syria is a unique tapestry of different cultures, different sects, and but because everyone loves the president so much, it's not going to go the way of the other countries of the Arab Spring. The second part of it wasn't true. The first part of it was kind of true. I mean, it is
you could get in anyway in the beginning, and even now it's difficult to report,
Sure. But the closest equivalent is two equivalents, the countries which is between Lebanon and Iraq, and both of those haven't had happy histories at all when the consensus, to use that word again, is broken down between the various groupings that make them up. I mean, one can't be optimistic about what's going on in Syria. I mean, too many people are dying now. There's too much too much call for retribution. But one has to hope that it resolves. So I don't have a solution.
We can continue over in our reception downstairs. Thank you for joining us, and thank you for this wonderful.